sir. So the first question that I had for Mr. Pettit is, how did mentorship play a major role in your success?
Well, I was very fortunate coming out of a very strong male family. When I say strong male family, my father had 11 brothers and one sister. And so I had the opportunity to grow up in a situation which was not only a strong male presence, but all of them had gone to Antioch University. When I say all of them, about 6 or 7, and they had gone into very productive fields. And so I always had the opportunity to be around persons who were academically inclined, and particularly my father. My father was just a strong person in terms of academic achievement. He was an electronic engineer, an electrical engineer, and had gone through Antioch University, as I said, and had been a brilliant student. And so I was always, that was a two-pronged situation, because I was always under the gun, if you want to say, in terms of my academic achievement. It was no way out. I was very much consumed with athletics, and I was very fortunate that my uncles and all were athletes. And I say in my book, I didn't have to look for athletic stars or entertainment stars to model after or to adopt as role models. I was very fortunate to receive all of that from my family.
Fantastic, fantastic. Well, speaking of athleticism and academics, LJ, you had something you want to mention about the HBCU?
Absolutely. So there are some people who support getting rid of HBCUs. As an alumni of an HBCU, do you support this notion? And if not, what do you think should be done to raise the profile of the HBCUs from their current status?
Well, LJ, I'm a very ardent supporter of the HBCUs, having graduated from an HBCU, Howard University, undergrad and law. And I just think they have filled such a major role in the development of American society, in providing opportunities that heretofore African American people were not available to get, or was not available to African American people. And having filled that void, they still play a tremendous role in terms of the African American community, as well as individual African American persons who are seeking to achieve academic excellence. I might also add, which you did not mention, I'm not sure that you're aware of, I was on the Board of Regents for 2 terms for the University System of Maryland, and appointed by Governor Bob Ehrlich. And my charge when I was nominated and when I was sworn in from the government was to go in and fight for the HBCUs because they had not been adequately represented in terms of funding and economic distribution. And so I had the opportunity to lead that battle on the Board of Regents for the University System of Maryland, which includes 11 universities and colleges for, I guess, 7 to 8 years. And so I'm very much aware of the difficulties. And one of the biggest things, LG, that's happening right here in the state of Maryland is that the HBCUs are still in litigation, which is serving as a national model that the nation is watching to see the results of this litigation, which has been going on for approximately 3 to 4 years. It came about in what they call a duplication of courses, and to try to be very brief about that, that was when what they call the traditional white universities began to duplicate some of the courses that were being carried and had been handled by the HBCUs, and therefore disturbing their enrollments and their ability to attract students and what have you. And the court found that Maryland had a history of discrimination in terms of HBCUs historically, and we're now in a stage of the trial and mediation when the court's going to convene next month, in fact, to let us know whether we are in terms of the mediation was in fact successful or not. But Maryland has been historically, in violation of the Civil Rights agreement that it entered into years ago. It's also a legal opinion called the Foresight opinion, which declared certain, almost like the Brown decision, certain declarations from the Supreme Court in terms of HBCUs. And Maryland has been in violation since the late 90s and has said, okay, you caught us, you got us, but we're still going to be obstructionists and defiant, and we're not going to, in fact, do anything about the condition of the HBCUs in terms of the equitable distribution of funds. And so we are in a very historic time, to answer your question, because this court has ruled in our favor, and the question is now going to be the remedy to, in fact,
Okay. Well, for me, after reading your book, I see that you played a very intricate part in history. Do you mind sharing with our audience how you played a part in history and some of the cases that you were faced against?
Well, Alfonso, I was very fortunate. It happened through unfortunate means. My father was an employee for Fort Holabird as an engineer, one of the first African American, if not the first, hired back in the 50s. And he got transferred all of a sudden because of the engineering laboratory that he worked for was transferred to Aberdeen Proving Ground. And so we transferred to Aberdeen. I was living in Turner Station at the time, which is basically a historical, predominant African American neighborhood. All of a sudden, my dad comes and says, "We're going to go to Aberdeen." And what? You know? And I was in the middle of playing ball and doing all the things that successful in undergrad. I mean, not undergrad, but junior high school. And all of a sudden, we end up in Aberdeen. And not knowing to us, we go trotting up to the Aberdeen High School. Al Ripken was alumni of Aberdeen High School, but at the time, Aberdeen High School was segregated. And we didn't know that, but we ended up in the United States District Court for the District of Maryland, federal court. And one of my lawyers was Thurgood Marshall, along with Jack Greenberg of the NAACP, Juanita Jackson Mitchell, and Tucker Durham. Well, we won that suit, and I was ordered into Aberdeen High School. And I call that the trilogy of litigation because that was my first involvement, was as a plaintiff to integrate the schools. Now, this was 1958. This was 4 years after Brown versus Board. But Aberdeen, the argument for the county was they were protecting me because I was not intellectually capable to compete with white students and so forth, and so therefore I should go to the segregated black schools. But the judge, even though he didn't find in my favor for Brown versus Board of Education, the irony of it was that he found in my favor based on separate but equal, that the African American schools were not academically equal to Aberdeen High School. So said, "Young Pettit, if you want to go in, it's your choice to fail." And so Chief Judge Roselle Thompson of the Maryland U.S. District Court at the time ordered me into Aberdeen High School. But the interesting part about it, I didn't have a problem because I was an athlete. I wanted to play football. Really, that was my reason for wanting to go to Aberdeen High School. They had a football team, and the black schools didn't have football, just basketball. But I got in, and the kids accepted me after I got over the first hurdles. The kids loved me, and, sort of a little light football star. But my father is the one who suffered, and this is where I talk about the litigatory chain. My father suffered because they put Dixie, played Dixie when he came into office. They put on rebel flags in his office. They referred to him as boy, and it goes on and on and on. Well, I had the opportunity to finish Aberdeen High School, finish Howard University, finish Howard Law School, and take my father's case against the United States for employment discrimination, take it into the second highest court in the nation, the United States Court of Claims. And in 1971, we won the case, Pettit versus the United States. My father was the first African American in the nation to be awarded back pay in terms of discrimination in the federal government. And the case did two things. Number one, it established that what they call a but-for test, how you prove discrimination in a federal courtroom. And number two, what is being argued today by President Obama, the case relied on executive orders, not acts of Congress, that discrimination was illegal, and there was a remedy. So what's so interesting, gentlemen, at the time I was practicing law, of course, and coming back into Maryland, and when we won the case, we got national acclaim. And when I would go into a federal court, judge would always look over and say, "Mr. Pettit, by any imagination, are you related to have anything to do with Pettit versus the United States? Since your name is Pettit, I always say, because he said the rules of evidence and the rules of procedure will be governed by Pettit versus the United States. And with great pride, I used to say, yes, George D. Pettit, that's my father. I was my father's lawyer. And so the third element of that trilogy that I talk about in the book is when I came home from Washington or was coming home to practice law in Maryland, which was always my ambition, to come back to Baltimore. I was failed on the Maryland bar. And I say I was failed because I know I didn't fail it. I was failed on the Maryland bar, and I took that into federal court, Pettit versus the Board of Law Examiners for the state of Maryland, which remedied a lot of discrimination against African American bar exams throughout the country because it was a precedent-setting case. So that's what I call the litigation history that was my small impact on the American judicial system.
Well, you've been referencing your book a few times. This is the book Under Color of Law by A. Dwight Pettit. If you want to hold a copy up for our viewers?
Sure.
That's fantastic. Now, actually, in the book, you mentioned briefly with LJ, you're referencing with Governor Early. This wasn't your first delving into politics. Under Jimmy Carter, you were under consideration for U.S. Attorney General. And now, with the foresight you had in the book, almost an uncanny ability to see the police brutality issues that we've been having recently in the past few years coming to light, what is your representation, or I guess opinion, on the impact that the Attorney General, the U.S. Attorney, has on these police brutality cases, more so referencing Eric Holder with the Michael Brown case?
Well, Chris, let's break it down so we have a clear understanding of what we're talking about. You're right, I was very fortunate. I met Jimmy Carter very early, became very close to him and his administration, both the campaign and after he was elected president of the United States. I was nominated for U.S. Attorney for Maryland, not Attorney General. Correct. Attorney General is the national. Eric Holder was the national Attorney General, and that's for the whole Justice Department. But in those days, that was unheard of. What President Carter attempted to do by attempting to appoint me U.S. Attorney for Maryland was unprecedented. There had never been an African American nominated. We take it for granted now because the Attorney General is African American male. We now have Loretta Lynch, an African American female. But in those days, to be nominated for U.S. Attorney for a southern state was quite controversial. As the Washington Post, I would never forget the headline of the Washington Post said, "Pettit blows in the wind," because the nomination stayed up in the air for so long, trying to solicit the support of Congress, because you have to get a set, just like with the U.S. Supreme Court. You've got to get the referral from the senator, and then you've got to get confirmation in the U.S. Senate. But having said all of that, I think the Department of Justice has a tremendous role to play in what's happening in terms of police brutality. In the book, the book was first published in 2012, and I predicted at that time that the civil rights issue of the 21st century would be police brutality. Unfortunately, I didn't mean to be so accurate, but I was. The department, the responsibility, I wrote a letter to Hillary Clinton, Secretary Hillary Clinton, about 3 weeks ago. And I said, people are saying, what are African Americans asking for in terms of making demands for the Democratic Party? And I was asked for three things. Number one, job programs. Number two, I'm going to ask for enforcement of the Civil Rights Acts in terms of the Justice Department's authority to, in fact, enforce the civil rights laws, and particularly not just on a civil basis as we see now, but also on a criminal basis, and that you should formulate a task force that will go into these states and enforce the Voting Rights Act, even though it's been decimated by the U.S. Supreme Court at this point in time, but the Civil Rights Act in general, under 42 U.S.C., which is the civil aspect, of 18 U.S.C., which is the criminal aspect of the U.S. Code, which gives authorities. In 1871 is when it was written, believe it or not. It was put into effect by Ulysses S. Grant, who was the general for the Union side of the forces, and later became President of the United States. And at that time, blacks were being so persecuted in the South, and hung and lynched and all types of atrocities. He went in to Congress and asked for protection so he could send in federal marshals and federal troops to protect the newly freed African-American slaves. And my argument to her in this letter was you still have the statutory authority to do that, even without the Voting Rights Act. You have the statutory authority, which is vested in 18 U.S.C. 1871 was the date of that. And last but not least, I ask that we not just get a Supreme Court justice, progressive Supreme Court justice, but I think the African American community, with its commitment to the Democratic Party, is deserving of an African American progressive Supreme Court justice. Whether that may be male or female, I could care less, but I think at this point in time, I don't count Justice Thomas as African American. We are overdue, and she should make that political commitment to the African American community.
Fantastic. We're definitely in a great role here, but we do have to take a short break, so stay tuned with our guest, A. Dwight Pettit. We'll be back after a short break. This is Men at Large. Welcome back to Men at Large with our guest, A. Dwight Pettit, author and previous counsel on numerous cases within Maryland and United States. I'm Chris DeBoard.
Alfonso Mayo.
I'm LJ Moses.
Now, LJ, you mentioned you had a question since we ended on a Supreme Court note. You got something you want to follow up with A. Dwight?
Absolutely. So, if you were the President of the United States and you had to appoint the next Supreme Court justice, what qualities would you look for in your ideal candidate?
Well, that's a very good question because we have, in my opinion, we're going to have, the next president is going to have 2, 3, and possibly 4 Supreme Court appointees, not only because of the death of Justice Scalia, but because of the remaining justices. 3 of them are over the age of 77, 78 years old. And so the next president will basically set the framework of our society for the next generation and thereafter, because the Supreme Court is for life. And Mr. Trump indicated that his ideal Supreme Court justice was Justice Scalia. And I take great issue with that, because Justice Scalia was not only one of the more conservative justices in the history of the court, but has said some things from the bench which, in my opinion, make him sort of biased against people of color. Now, having said that, to be directly with your question, I would say that the ideal, just like candidate Trump has indicated Scalia, the ideal candidate or ideal example for the next Supreme Court justice would be my lawyer, the great Thurgood Marshall. I think Marshall exemplified not only academic excellence as being one of the more brilliant lawyers in our nation's history to argue before the court. He was Solicitor General of the United States. He was head of the Legal Defense Fund of the National Office of the NAACP out of New York. He was one of the greatest lawyers in the country. And we talk about Johnny Cochran, but he's a friend of mine. But Thurgood Marshall was just somebody that I idolized. When we talk about Martin Luther King, we talk about Adam Clayton Powell, and other great African American leaders. A lot of people don't give Marshall the credit for not only his academic excellence at Howard University, my alma mater, but the fact that the man just did phenomenal things in terms of his own individual courage of going into courtrooms in Texas and Deep South, where they had to bring him in a hearse to sneak him on at least one occasion and maybe more. And the fact that he would travel without an entourage throughout this nation to argue the cases that would go on to make landmark history, Brown versus Borden, etc. And so he has all the qualification of experience, interpretation of the Constitution in terms of the Constitution being a progressive, growing document that encompasses the issues of today. Because you got to remember, when the Constitution was first written, we as African Americans were property. We weren't people. And then you got to remember, along came Dred Scott decision, which said that we as a people, African Americans, had no rights that a white person had to respect. So the court has been in an evolution stage, and we've had some great justices. Remembering Black Justice Black, who was a member initially of the Ku Klux Klan, and of course Justice Warren, who was appointed by Eisenhower, that pivoted and became one of the great justices in terms of the opinion of the Brown versus Board of Education. And Judge Douglas, and I could go on and on. So, Mark, I think Thurgood represents all the positive aspects that you would want in terms of experience, courage, academic qualifications, historically speaking, of a Supreme Court justice. So that would be my role model as to the ideal selection by the next president of the United States.
A lot of great talking points, and definitely naming some names that I think we're all familiar with. I think, Alfonso, that brought up something you wanted to speak on?
Yes, sir. Well, in a previous interview, you said that the book, it was inspired by your father on his deathbed. Under Color of Law is an interesting title. Could you explain to our audience why you chose that title?
Well, I chose the title, not only was I telling my father that I was going to tell our story, but I chose that title because America is a young nation. And when I say it's a young nation, it can change. The pendulum of justice and the pendulum of our nation politically can shift very quickly back to conservatism or to progressive policies. And we have seen that shift on several occasions. And one of those shifts are what I talked about in terms of President Ulysses S. Grant. When Lincoln died, we saw a major shift in the nation with Reconstruction going on to really apologize and bring in the South and sort of forget and forgive what had taken place. And what Grant did with the passage of 42 U.S.C. 1983, formulated in 1871, was the main civil remedy for protection in the federal courts. What he did was basically put some enforcement and teeth into the 13th Amendment, the 14th Amendment, and the 15th Amendment by allowing federal marshals and all to go in. And part of that provision that I quote, under color of law, comes right out of 42 U.S.C. 1983 and 18 U.S.C. 252, which are the civil rights protections for African Americans during that horrendous time, and allowed Grant to send marshals in to destroy the vestiges of the Ku Klux Klan. The Ku Klux Klan would basically resurrect as the country shifted politically going into the 1900s and reestablished with the birth of the nation, the first original birth of the nation, not the one that's playing now. And so, under color of law, the statute in itself says any person, and I'm paraphrasing, any person acting under color of law to deprive U.S. citizens of their constitutional rights shall be liable criminally as well as civilly. And so that encompasses at that time, all the mayors and the police chiefs and the police officers and the officials who, under color of law, were acting legally in their minds to do the horrendous things that they were doing to African Americans. The under color of law statute, which at that time was called the Ku Klux Klan Act, in fact gave the federal government the teeth to come in and protect the newly freed African American slaves. And so, as I say in the book, while we're sitting celebrating, a lot of, young people, especially millennials, no offense, gentlemen, but a lot of young people used to say, well, the civil rights movement is over, and, blah, blah, blah. And it's not over. The country can drift back very, very quickly. And so the under color of law was to warn America of what can possibly happen if we're not politically vigilant.
I have one last question for you, and this is a police brutality question. Do you think there could be better weapons alternatives for police? For example, instead of guns, maybe have police carry batons or bats?
Well, that's something that might have happened in Europe, but I think our culture here in this nation makes law enforcement, it makes it a necessity to be armed. So I don't really dispute the fact of them being armed, not disputed, the training and the policies and procedures which have led to the negative use of that armament. Now, if you take your question a step further, I do think it becomes an issue when they talk about the militarization of the police departments in terms of anticipation of future civil disobedience, civil disorder. That can take us down the road to dictatorships and down the road to lack of habeas corpus and military rule in this nation, which is a very dangerous path.
Fantastic. Alfonso?
My final question would be, the United States currently has one of the highest incarceration rates just in the world in general. And since the 1920s, we have seen the imprisonment of African Americans in general increase about 400,000 per year, and the number is continuously going up. Some will argue that there's a loophole in the 13th Amendment. Can I have any feedback on that?
Well, you open in a very interesting area. And you're right. As we see this progression of incarceration, and that's why we're looking for a reformation in terms of the judicial system and the prison system in this nation. Obviously, and I think Bill Clinton has admitted it, that he was wrong in terms of the war on drugs, because it turned out to be a war on African American and Hispanic people. And what this did in terms of mandatory sentencing, in terms of sentencing guidelines, where it took the discretion away from the judges. It disrupted families, it destroyed personal economies and what have you. And we see that continuing. Now, when you talk about the 13th Amendment says you can't have slavery is illegal, but it made the exception on terms of debtor court and whatever, you owe debts and so forth. And so what happened in terms, it's called peonage now, but what happened in terms of the history of America was they didn't have the slaves to work the plantations, and they looked around and said, well, we got to have somebody to work the farms and plantations. So they came up with the peonage system, which was to get around the 13th Amendment. If you owed anything, if you owed $1 for a quart of some milk, or you didn't pay this or pay, you could be thrown in prison. And so that began to fuel what you begin to see as the economic rise of the criminal justice system as an economic enterprise, rather than about law and order or about criminal punishment. And that's what we see today when we see institutions across this nation perpetuating and supporting a whole new industry in terms of putting folk in jail. Jobs, whole communities built on the prison system and what have you. And so, yes, we're at a crossroads, especially in the African American community, where families have been destroyed, people have been destroyed, with all this zero tolerance here in Maryland, for example.
It's a very powerful discussion, regarding the judicial system of past, present, and future. But with that, we'd like to thank our guest author, A. Dwight Pettit. The book is Under Color of Law, available internationally from your local retailers. Is there anywhere else they can find the book?
Amazon.com and Barnes & Noble.
Fantastic.
And of course, the publisher, Our Universe.
Wonderful.